Can two parties secretly settle a dispute or proceed with private arbitration while a court case is already pending? And if they do, will that settlement or arbitral award stand in the eyes of law? A recent Supreme Court judgment has reignited this important legal debate and raised critical questions about settlements, arbitration, and pending court proceedings. If you are involved in a property dispute, business dispute, partnership dispute, or any civil litigation, this judgment could directly affect your legal rights. In today's video, we will examine what the Supreme Court has said, why the prescribed legal procedure matters, and the serious consequences that may arise if parties attempt to bypass it. Stay with us till the end, because one procedural mistake today could lead to years of litigation tomorrow. Friends, welcome to your YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan. I am happy that our channel has completed 1 lakh subscribers and has received the YouTube Silver Creator Award. Thank you for your continuous support. For more legal awareness videos, subscribe to the channel free of cost. You may also support the channel by taking a membership of 59 rupees or 119 rupees through the GPay QR code displayed on the screen. Thank you for your continued trust and support. Now let us move towards today's main topic. Introduction. If a civil case is already pending before a court and, during the pendency of that case, the parties wish to settle the dispute amicably or resolve it through arbitration, what legal procedure should they follow? A recent and landmark Supreme Court decision has highlighted important and strict principles relating to this issue. What was the case about? According to reports, a civil suit concerning a property dispute had been pending before a court since 1982. This long-standing conflict culminated in the Supreme Court of India's ruling in Ashok and Ors vs. Padam Chand and Ors, 2026 LiveLaw, SC 570, which was delivered on 29 May 2026 by the bench of Justice J.K. Maheshwari and Justice Atul S. Chandurkar. During the pendency of that suit, the parties proceeded with a private arbitration without seeking the permission or leave of the trial court and eventually obtained an arbitral award. Subsequently, rights were claimed on the basis of that award in an attempt to dismiss the ongoing civil suit. This gave rise to a critical legal question. What is the legal effect of an arbitration conducted while judicial proceedings concerning the same dispute are already pending, and can such an award be treated as directly enforceable to end a pending suit? What did the Supreme Court say? The Supreme Court, in the case of Ashok and Ors vs. Padam Chand and Ors, 2026, emphasized that when a dispute is already the subject matter of pending judicial proceedings, parties must comply with the procedure prescribed by law. The court stressed that even when parties choose an alternative dispute resolution mechanism, such as arbitration, during the pendency of court proceedings, the process must conform to the applicable legal framework. The Supreme Court held that any arbitral award passed without obtaining the explicit leave, permission of the trial court is non-est, does not exist in the eyes of the law and cannot be used to defeat or dismiss the pending civil suit. Difference between settlement and arbitration. Before proceeding further, it is important to understand the distinction between these two concepts and how the law treats them when a case is active. Settlement. A settlement means that the parties mutually agree to resolve their dispute and bring the controversy to an end. Under Order 23 Rule 3 of the Code of Civil Procedure, CPC, a compromise must be recorded in writing and signed by both parties, and the court must be satisfied that it is a lawful agreement before passing a decree. Arbitration. Arbitration is a process in which the dispute is referred to an arbitrator, who hears the parties and renders an arbitral award. An arbitral award acts like a formal court decree, but if it is initiated privately while a civil court is already handling the exact same matter, it lacks statutory jurisdiction unless deep structural rules are followed. The determinative factor, court's leave versus knowledge. A key highlight of this recent Supreme Court judgment is its interpretation of Section 21 and Section 47 of the Arbitration Act. The respondents argued they did not have active knowledge of the pending suit when the private arbitration started. However, the Supreme Court rejected this completely. The court ruled that the legislature makes the institution or pendency of the suit the sole determinative factor. Whether a party claims they knew about the court case or not does not matter. If a suit is pending, going to private arbitration without court permission makes the eventual award completely unenforceable. Importance of Section 21 and Section 47. While Section 21 deals with the commencement of arbitration, the Supreme Court heavily focused on Section 47. Under the law, an arbitration award can only be treated as a valid compromise or settlement in a pending civil suit if all parties give their post-award consent to accept it. In this case, because the plaintiffs did not give their explicit post-award consent to treat the private award as a final compromise, the courts cannot force it upon them to dismiss their suit. Failure to follow this prescribed procedure subsequently renders the entire arbitral award invalid and legally dead. Why is the court's role important? When a matter is already pending before a court, the court performs functions beyond merely adjudicating the dispute. The court also seeks to ensure that the settlement is voluntary. There is no fraud, coercion, or undue influence. The rights of all parties are adequately protected. Future disputes are minimized. For this reason, adherence to the proper legal process in pending matters is considered highly significant. Private setups cannot bypass the established authority of a court once a suit has officially begun. What happens if an award has already been passed? The principles discussed by the Supreme Court indicate that merely obtaining an arbitral award may not always be sufficient. If there are legal objections concerning the procedure adopted, specifically, if it was conducted behind the back of an active court docket, questions will arise regarding the validity and enforceability of the award. The Supreme Court has made it clear, such an award is a manifest error of law and cannot, non-suit, dismiss the plaintiff. Key takeaway for the public. If you are involved in a property dispute, a partnership dispute, a family dispute, a business dispute, or any other civil litigation, and the matter is already pending before a court, it is completely unsafe to assume that a private settlement document or an unauthorized private arbitration award alone will conclusively resolve all legal issues. Obtaining proper legal advice and following the required legal procedure by moving an application before the presiding judge is the only legally secure course. The Supreme Court's core message. The broader principle emerging from this decision is: where a dispute is already pending before a court, any settlement or arbitration process must be undertaken strictly with the leave and supervision of that court. Ignoring the prescribed legal procedure may wipe out years of your arbitration efforts, turning your hard-won award into a mere piece of paper while your original court case continues. Conclusion. Friends, this recent decision highlights the following important points. Settlement during a pending court case is possible. Arbitration during a pending court case may also be possible but strictly requires court permission. Claiming ignorance or lack of knowledge about a pending court case will not rescue a private arbitration award. An arbitral award achieved during a pending suit cannot act as a settlement unless all parties explicitly consent to it post-award. Professional legal advice should be obtained before taking any significant step. Thank you for watching this video. If you found this information useful, please like the video, subscribe free of cost, and share your views in the comments. For more legal insights, do not forget to press the bell icon. I shall meet you again soon in the next video. Jai Hind! Jai Bharat!